Good afternoon. Are you Jose Lopez Garcia?
No.
Which case are you guys here on?
We're here on the eviction
What's
of
your name?
David and Chelsea.
David and Chelsea what? Horner, Holman and Dick? Okay, I got you. All right. You're the 125. You're a little early, but you're in the right spot. Let me give you a name. All right, I'm going to put you in the waiting room for a minute, so don't go away.
Hello.
Good afternoon, Bettina.
Afternoon, how are you?
I see Lisa back there hiding in the background. I can still only see the top of your head.
I
You
know.
gotta touch the camera a little bit or get a booster seat.
Yeah.
Anyway, I sent you that stuff. We got a lot of customers this afternoon.
Cool.
Our 125s have checked in, and then our first one hasn't. We got 115, 125, 130. We got two at 130. Anyway, we'll start bringing them in here shortly. Hopefully, these people have tried to make an effort to contact you. We'll find out here.
They have, and unfortunately, two of them don't qualify for the program. And we made an attempt to contact them and let them know.
All right. Did you get those things I sent you from Lance Thornton?
Yes, I
Easter
have.
House, since that
Yeah.
before?
Mhm.
All right, thanks.
Yeah, thank you.
All right, let me get set up here. I need a bigger desk. I got too much stuff spread out here. The files, the electronic files, the keyboard, the notices. Try to keep it all straight.
That would come in handy.
One of the problems is my laptop, or the monitor for the computer, has a camera to my right, the camera for the Polycom is at my left. So I'm looking two different ways, but I tend to focus on the one at the screen because that's where I see the people in front of me on the screen. This morning we had 17 people on camera all at the same time.
Oh, wow. It kind of reminds me like the Brady Bunch, how the little screens are in
Somebody
position.
also showed a Zoom meeting, it showed the beginning of the Muppet show where it had all the people in little compartments.
Yeah.
That's what a Zoom meeting looks like, the opening credits to the Muppets. I also have some general civil cases, some small claims cases, and then more landlord tenant. So I have a 145, we go to 135, then I have a 145 civil case, then we break from 245 to 330. That's not going to be enough to do our small claims cases, but never know how things shake out. Anyway, we have a lot to do before we get to where we're going. Well, it's 1:13 and neither of our 1:15 parties are here yet. I'm a bit surprised. Well, I have no proof of service, so maybe, well, that's not uncommon for Andy Rognes. He brings it at the time of the hearing. If the defendants come in, I will advise them of their rights at the same time we do the next case, but can't do anything without anybody being here.
Mhm.
June 30th. I'm very surprised that no one is here on that case.
Uh,
We sit here and twiddle our thumbs. Have you talked to Chelsea Holman and David Dick?
no, sir, I haven't.
Well, this is our first hearing, so. Well, this is frustrating. We got a lot to do and we're spinning our wheels and burning daylight. I sent Mr. Rognes an email asking us to join.
Yeah, hopefully he gets it. And
There may be something going on I don't know about.
yeah. If the feedback is too much, I can mute.
You're fine.
Okay.
You're fine. Two people have entered the waiting room. Scott Larkins. He's not here until a little bit later here.
1:30.
Yeah. Lisa's phone. Let's see who this is. Lisa Jacobs, I think. Good afternoon. Are you Lisa Jacobs?
Yes, I am.
Oh, you're a little early, but let me give you a name here. All right, we've got somebody named Mojo E5 Plus. Moto. Mr. Moto. Not Mojo Ryzen. I'm gonna bring the other parties in. Good afternoon again, Mr. Larkins. We're trying to struggle to get all our people in here. I've got Moto E5 Plus, who I don't know who you are. Got a nice shot of their ceiling. Mr. Holman and Mr. Dick, you're sideways in the screen. Also, kind of hold off on the PDA. We're live on YouTube, and there are people watching. Who am I speaking with?
Hello?
Yes, who am I speaking with?
This is Tiffany Wyrick. I believe I'm trying to join.
Yeah, Tiffany, I can't see you. Let me give you a name.
Okay, let me go back on it, or I can go back and rejoin with video.
Okay.
Oh, I pressed the button. I figured it out.
All
Okay.
right. All right, just stay where you are. We've got other business to transact. I don't know who Moto E5 is.
Okay, I'll be quiet.
All right, just keep quiet, and we've got one more person to bring in, and we're gonna give everybody their rights.
Okay, thank you.
All right, I muted Ms. Holman and Mr. Dick for the time being. They've got a small child. All right, our 115 case never showed up, so I don't know what's going on with Lopez Garcia versus Adams. Our next case is set for 125, and it is 125. We've got David Dick and Chelsea Holman here in file 21416. We have Tiffany Wyrick here in file 2115LT. And we have Ron Hughes and Lisa Jacobs here in file 21402. We also have Bettina Emery here, our housing advocate from Keystone. I'm going to go live here, and I'm going to advise each of you that you have certain rights under the landlord-tenant law. I don't know who Moto E5 Plus is. Hopefully you can hear me. As a defendant in a landlord-tenant proceeding, including non-payment of rent, termination of tenancy, land contract forfeiture, mortgage foreclosure, or other premises actions, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case Keystone, or other program may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. The summons and complaint are sufficient, and all of you have already received a summons and complaint. That's what starts the case. If the plaintiff is agreeable, the Citizens Mediation Services, Inc. may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can facilitate that. If you reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. All right, our 125 is Sturgis Place Apartments versus Chelsea Holman and David Dick. Ms. Holman and Mr. Dick, can you unmute your mic? Mr. Lance Thornton is here on behalf of the apartment complex. He provided the court with a judgment information sheet indicating that through April, you owe $2,354, but I would take $120 off of that for late fees, which would be $2,234.74 to pay your rent through April. Is that correct, Mr. Thornton?
Yes.
Mr. Holman, or Ms. Holman and Mr. Dick, have you been in contact with Keystone?
No, we did not know about Keystone. We went through our caseworker at the DHS office and we filed for home assistance thing.
They said that it'll take up to like 10 days to get it confirmed and to get it complete.
All right. Well, I would strongly advise that you also contact Keystone.
Okay.
Federal money has been set aside in what's called eviction diversion programming. Because of COVID and even before COVID, people were at risk of losing their residency because they couldn't pay the rent. Federal money has been earmarked to help people pay the rent. It helps the people, but it also helps the landlords who certainly are entitled to have their rent paid. The law requires that I set this for a second hearing. Lance, I'm going to try to set both of these for the same day.
Oh.
What I'm looking at, we've got vacations in here which jam up some of our dates. I think you're set to be here next week, next Monday, April 12th. So
correct,
Lance,
Your Honor.
what if we continue this to April 12th at 1:30?
That's fine with me.
Do you have the information for Keystone? I think I sent it. Do you have something to write with?
I
No one
can.
ever. Are you ready?
1 second.
Well, I'll have it recited to you. You can write it down. Mr. Jacobs, Ms. Jacobs, you may want to write this number down as well.
We're getting a pen ready right now.
Okay,
I
we're
got it
good.
right now.
All right,
Go ahead.
go ahead. Tina, state the number.
269 467
467
7078
078.
extension 117.
Okay.
All right, so we're continuing this matter for 1 week till next Monday, April 12th at 1:30. I do strongly direct you to contact Keystone. Also talk to your DHS worker. There's going to be some emergency housing money that can get your rent paid and pretend stay this eviction. Do you have any questions?
No, Your Honor.
All right, you're free to go.
Okay, thank you.
All right, thank you.
All right. The next case is also Mr. Thornton's, and it is Green Valley Apartments versus Ron Hughes and Lisa Jacobs. And I don't think I got one of those sheets on this one.
You did not, Your Honor. This is a termination of tenancy,
Oh,
not a non-payment.
oh, yes, it is. Yes, it is. Green Valley Apartments. This is a termination of tenancy. There's no lease in here because I don't think there is a lease. The notice to quit says that you're living there without benefit of a lease and you aren't paying rent, and they want you to move. Tenants are not paying rent and refuse to pay rent, and they don't want to move. The rights I read to you indicated you have the right to get an attorney or contact legal aid to attempt to get some assistance. What's your position here?
You're talking to us, Your Honor?
Yes.
Okay. We had originally made an agreement with the owner, the father, Reno Santori. Anyways, it was just a verbal agreement. We shook on it. And we'd ran the apartments for a decade. My girlfriend did. She was the manager. He had me out working on the grounds crew at the golf course and doing maintenance at the apartment buildings. Anyways, Mark became CEO a couple years back, and I was injured last year. At the end of the season, I hurt my back out working on the golf course. And this is all trying to sweep us under the rug and make us look bad, which we're not bad people, Your Honor. We had won 2 court cases for the apartment complex in your courtrooms. Hands down, the judge told Reno that Lisa should be his attorney. We're not bad people. We're not trying to drag this out. We do not want to drag this out. We want to move way worse than what the owner wants us to move. We are in the process of finding a place, but everything with COVID, everything's either tied up or disappears before you get to it. We've missed out on 2 homes. We were a week late on one home. We just missed out on another home. We were a day late. It's all a matter of circumstance.
You're $1 short?
No, no, we had the money for the spot. We were just a day late.
Well,
We're
what
trying
you're telling me,
very hard.
I hear very, very often, people would move if they had somewhere to move to. And the old saying that a handshake agreement is not worth the paper it's not written on, you have to have a lease to protect you and protect the landlord. So there is no lease, they want you to move. They also say you're not paying any rent. So that's not a good situation. But
No,
the
it's
law
not, Your
requires-
Honor.
The law requires that I set this for a second hearing. I'm going to continue this also to next Monday, April 12th. And the day is very busy, but it's before we miss some dates. Lance, I'm going to set this for 2 p.m. Now, you've got a couple options. You can hire an attorney, you can ask legal aid to represent you, or you can just move. If you do move, you need to turn in the keys and get the forwarding address in writing with 4 days of moving. Next Tuesday, if I give them what they asked for, next Monday. Next Monday is April 12th. If I give them what they asked for, you'd have to move out by April 22nd, 10 days from that date. So
Well, we're not, like I said, we're not trying to drag anything out or give anyone a hard time. I was an Eagle Scout and honorably medically discharged out of the Army. I'm an honorably discharged vet on disability. Because of my hurt back, I was kind of, I don't know. I'm just praying we find a place is all I'm praying. That's all we're working for.
all right, well, we'll hear more about this next Monday, April 12th at 2 p.m. All right, do you have any questions?
No, sir. Hopefully we'll have some better news by then.
All right, thank you.
Thank you. Take care. Have a good day.
All right, thank you. Lance, we're gonna have our work cut out for us next Monday, but I'm trying not to set any of these cases, if I can help it, in front of Judge Pattison. I'm gonna set some first cases, but I wanna set any second ones. So we'll do what we need to do. Does that finish your obligations here this afternoon?
No, I've got 2 more, Your Honor.
Let's see what you got. We got Sturgis Place at 2:25 and 2:30. I'll see you in a little bit.
Okay, sounds good.
Mr. Rognus has joined us. Andy, I know you didn't think you were gonna be here, I don't have a tie on. I had Lopez Garcia.
Already?
What?
Didn't you get a dismissal?
If I did, it didn't make it to me, so there's a
Oh.
dismissal? All
Yeah.
right. All
Yeah,
right.
I thought I emailed you early this morning.
Well, I looked just before I came in here to see if you did. And,
Yeah, I thought I emailed you about 9:30.
oh, I've been in court since 8 o'clock. Let me look
Oh.
here. I got your email regarding,
No, I emailed him. That's just-
Foreman and Weiderman.
Yeah, that's a copy of the judgment for Friday.
No, that's the only one I got.
Oh, Middleton J at stjoecountymi.org?
Yes.
Oh, okay, I thought I emailed to you, but yeah.
Well, I got the second one, but go ahead and send it again. I don't have a 9:30 email from you, but
Okay.
anyway, it's dismissed. I'll get the dismissal and you're off the hook, and thank you.
Yeah. Sorry about that. I thought we emailed you early on this morning.
Okay, thanks.
Okay, and no pre-trial for tomorrow morning
Yes, thank you.
for the village.
All right, thanks. All right, we still haven't figured out who Moto E5 Plus is. The Lance in the waiting room. Moto E5 Plus. We don't know who you are. All right, Miss Wyrick is here. Mr. Larkins is here. This is file 2115LT. I went through the advice of rights several times, but again today with Miss Tiffany Wyrick. We were here in February, then we were here on February 12th. The defendant was late, then she got disconnected, and then we were all chasing our tails. She indicated she was gonna move. There was a $7,800 arraignment that continued the matter till April 5th, which was after the CDC stay expired. And the CDC stay has been extended till June 30th. Ms. Wyrick, are you still there?
Yes, I am still here, but I actually have another place. It's just the landlord is, the other people have their stuff packed up, and I'm waiting for them to be out of the house, and it's already updated and nice and up to code. So I'm moving, and I meet with him Wednesday to hopefully get the keys. He sent me pictures of the interior. I've already been there before, and it's nice, and all the guy's stuff is boxed up. So I'm sure he said by Friday he should have all his stuff out of there, and I should get the keys Wednesday.
And now you've been there, we've been struggling with this for months through February, March, and April. Mr. Larkin says she paid any rent? You're on mute.
No, Your Honor, she has not.
This is a pretty sweet deal for you. You get to stay there in his apartment without paying any rent, waiting for someone else to have a place available for you to come to. We had the dispute as to who owes who how much money, but he's been trying to evict you since, I don't even remember when, probably the first of the year. Before that, notice to quit was served in December. So no rent's been paid for November, December, January, February, March, April. But there is another stay in effect.
May I speak?
Yes.
Okay. I've like been trying to move, and I've been trying to pay rent also, and like I messaged him about it because I'd rather not be on live. This is on Zoom live YouTube, so I don't want to disclose all of my private business on YouTube. But I have repaired lots of things at this home.
we talked about that before, but it doesn't necessarily give you a right to live there for 5 months without paying any rent.
Okay, but let me explain what I talked with legal aid for 3 hours, and I've talked with Anatasi Marcoux, which is my prior lawyer. He's a good friend of mine, Mr. Marcoux out of Kalamazoo, and he helps me with legal issues. I call him, and he gives me a rundown of what my best options are. And he advised me that whenever I was at this home in March of 2020, I was living in 612.5 in the back. That's where I was at for 2 years.
Stop. You told me all that stuff. Had it not been for these COVID stays, we would have joined this issue a long time ago. My hope was, though, I adjourned it all the way from February to April, that you would have moved or then we could still argue about those issues. You haven't been able to, and you haven't been paying rent. What I should have done is ordered an escrow order that you pay the rent in the meantime, while we argue about the other stuff. But Um,
Well, Mr. Marcoux said it was a constructive eviction, which is when you change the locks without
Well,
any notice or court
well,
stuff.
those issues are all still there, Tiffany,
And see,
but the point
if
of
you
fact,
could look
would you
at the
stop?
camera,
Yeah,
if you could look at the camera, you can see why. This is kind of why I'm not paying. This is
all right, well,
supposed
so
to be a room.
what I should be doing is ordering that you pay me, and I hold on to it until we finish fighting about it, but I didn't do that because you kept representing you were trying to move.
Yeah,
One
I
point
am moving. Yeah,
Well, you hold still, you're making me dizzy. I'm gonna fall out of my chair here.
Sorry, I walked to that room to show you.
All right, well, you showed it to me before.
Well, I
Mr.
sent you pictures. Did you not get any of the pictures that
Yes,
I emailed?
I got all of them. Like I
Okay.
said, I hope that this would be resolved except for the COVID stay. It got extended and it got extended again and got extended again. And, here we are.
Yeah, just like the prior people were saying that they're having trouble with moving slow and people are getting all the houses. That's kind of the same thing I was having. Is I had a
Well-
place in January, but if you don't move fast enough, they're getting them out because there's so much stimulus money. There's so much, and there's
Yes.
so many lockdowns where landlords cannot get the people out of the homes. So
Right.
us renters are having trouble getting a home.
Which is all fine and good, except the landlord doesn't get paid. He
Yeah, well,
hasn't gotten any. He
there's a
hasn't gotten any
program.
money.
There's a
Yeah.
program available to get the landlords paid now. Governor Gretchen Whitmore has signed the SURA program.
Yeah,
and
we're
I
well
called
aware of
her.
it.
I called them this morning and gave them a call, and we're working on getting him some money because even though I've done some repairs, I have lived here, and I would like to settle things peacefully.
All right. Mr. Larkins, what's your position here?
I just want to move on, Your Honor. I mean, if we could get her out, that'd be great.
Well, you're gonna have to get her out on her schedule. I'm gonna do a writ of eviction.
Well, that's the thing. I have a landlord I'm meeting. I feel like I don't need no eviction on my record when I updated both homes. They were full of roaches. They were full of.
Stop. You told me all this stuff. I'm gonna do the writ of eviction effective July 1.
What does that mean? I'm sorry, I'm not familiar with that.
Well, this COVID stay extends until June 30th. So, although this is a termination of tenancy action, so it was not a non-payment of rent. I extended it. Let me look at this.
Yeah, because I feel like I've actually done him a big favor. These houses were, oh my goodness, and now they're beautiful, both of them. I mean,
All right.
honestly, I'm being honest.
All right.
Like I made them livable and nice for the new tenant that comes in. Will be happy to pay rent. As a landlord, if you provide a nice home, the people are happy to pay rent.
Okay. Well, the problem is you're there, you're not paying rent.
Well,
He either wants you out so he can get rent, or he wants you to pay the rent. He alleged back in December you were $7,400 in arrears. Right now, you're probably $10,000 behind on the rent. So
Yes,
he doesn't get to make his payment.
That's why I was
And-
texting him today is we need to make an agreement on the numbers amount so we can move forward because Keystone
he
is
did-
ready to help me.
He didn't file it as a non-payment of rent case. He filed it as a termination of tenancy case. If
So
it
he
was a
can't get
failure,
paid?
well, not by Keystone, unless something is worked out. He just wants you to move, and he's wanted you to move since December. You have
Oh,
one.
may I
So,
say something? I think I'm confused. Your Honor, may I ask one question?
Yes.
So well, what's going on is if I just move out, I don't owe no money. Just call the U-Haul
No.
and get out.
If you move out, you may still owe money. He may sue you for all these months that you haven't paid rent. Now, basically, what he wants you to do is just move and get on with it. I think he's gonna call it water under the bridge. But you may be liable for $10,000 worth of back rent in a civil judgment. Now, you may have a defense that should be offset by some work that you've done, or rent should be abated, so you don't owe that amount. But $10,000 is, give or take, well, it was $7,400 in December 18th, and it's $200 a week.
We didn't agree to 200 a week, Your Honor, at all.
9, 10.
I would never agree to that much money. I don't make enough. I don't get enough money to pay that much.
Well, that's what the lease says.
We didn't agree. That's where we're having conflicting things. Can we have landlord-tenant mediation where we can agree to numbers and final things and move on?
Well,
Because
see, well, we haven't gotten to the numbers yet. He just wants you to move. If we have a damage hearing, then we would try to figure out what the rent was and how far it was in arrears.
yeah.
But when I talked to you back in February, you told me you would be out, so I continued the matter until today.
Yes.
And the check is still in the mail, and I'll still respect you in the morning, and I only had 2 beers. The rental agreement that's signed here, signed 3/1 of 20, signed by Tiffany Wyrick, says rent is $200 per week.
I never signed anything. I got the paper right here that says refuse to sign.
Oh, I see here, it says would not sign. All right.
Would not,
correct.
right, I was gonna say, I didn't sign no $200 a week because I'm on Social Security disability. I told him in March of, or January of 2019, or December of 2019, when I started thinking about moving here and Dwayne Pitcher was here, I told him if I move over there, I'll pay $600 a month and I'll do some of the repairs to help make it nice, like I did the other one. And we agreed at $600. So when he can,
Right, well,
he
let me
never,
ask- when did you
every
have,
month
did you
I
pay?
called him to pick up the money. He said, "Oh, I'll see you tomorrow. I'll be there tomorrow." He never came.
Well, when did you ever pay rent?
I paid rent whenever I was living at the 612 and a half thing. He never.
So in a year, have you ever paid rent on 612?
612 here? No, he never came back here. Once he put
So
that
you
guy
haven't
in
paid
the house
rent in
with
a
the door,
year?
he locked me out of my house and put the guy in my house at 612 and a half. He changed the locks, put my stuff in garbage bags, and the girl, his worker lady, Caitlin, they stole all my bags and my jewelry and stuff. And then I was forced to live in 612 and a half. That's why I've been calling Mr. Marcoux for legal guidance. Because
Well,
I'm
so-
feeling this is
All
wrong
right.
to do me like that. There is,
All right,
needs
well,
to be
it
justice.
depends on your justice. You've been living there for a year without paying any rent, not 1 penny since
But he
last
never
March.
came and fixed the place. I never wanted to live here. Once I realized he
I
wasn't
don't-
going to fix nothing. I live at 612 and a half in the back.
Well,
That's my
so
house.
so you had a year and a month to move. And
I've
you
been
haven't.
waiting to go to court to get my money back from fixing the other house. Really?
Oh, boy. All right,
Those
I'm gonna,
pictures.
I'm gonna set a hearing for termination of tenancy.
I just feel like it should be fair. At least the receipts I got from the Home Depot, all the stuff I bought, that should be took off of the rent or something. I don't understand why. All my work don't matter, and I made it all
All
there.
right, let's assume you did $3,000 worth of work. You got $200 of, anyway, it boggles my mind, but we're gonna join the question. We're going to set a hearing on the termination of your tenancy.
Let me get my
And
pen.
unfortunately, we're gonna have to do it after I return.
May I ask one question, sir? Because this could nip everything in the butt and I can get him paid and we can move on. Because I understand he needs money too. And I don't want evictions on my record. I care about my credit. So I wanted to ask if me and him agreed to $600, can he make it admit to that or whatever so that it could be the $600 what I agreed to? And we can move forward. I'll gladly do that because then that covers the little 400 was all my repairs. Monthly, I gladly repaired everything because I thought I was paying 600 a month. He knows I only get 800 a month disability.
$600 times 13 months is $7,800.
Oh, it's still 7,800.
So $200 a week times 56 weeks is $11,200. But even if, all right, I'm going to set this for a hearing regarding termination of tenancy for 1:30 p.m. for April 28th.
May I ask one more question? Because I called Keystone this morning and she said I filled out the thing and I have it. I printed it, filled it out, and I was going to fax it over to her. And the landlord, Scott, is supposed to fill out the other portion so that I can get him paid. And I'm gladly ready to do that.
Well,
I just want to know, so the 7,800, could he take off my?
Well, he could if he wishes to, but right now he simply wants to terminate your tenancy. Well, yeah, what's your thought regarding that, Mr. Larkins?
If she moves out on Wednesday, I would be very generous. I mean, you've seen me
You're from Wednesday, all right.
I just want to be done, Your Honor.
Yes, all right, so we're just gonna leave it as a termination of tenancy. In the meantime, you're gonna pay the rent at $200 per week to me.
What?
I should have ordered an escrow order a long time ago. We keep adjourning this and you're objecting to things. You're gonna pay the court $200 per week starting April 9th. Every Friday.
I never
Yeah.
agreed to $200 a week to him.
I don't care. I just ordered it at $200 per week. Now, if you pay it, it'll be on the 9th, the 16th, the 23rd. And if you don't pay it, when we have the hearing on April 28th, I'm not going to listen to anything you say. I'm just going to order a termination 10 days from April 28th.
So I should go ahead and file my civil lawsuit because Mr. Marcoux tells me to sue him because
well, knock yourself out.
The maintenance man was sexually harassing me, all the stuff I went through.
I don't know about that, but all I know is you've been there for a year, you don't have a lease that you agree on, you're not paying any rent, and because of the continued, although frankly, this isn't a COVID stay case, it's a termination of tenancy. I've sort of bent over backwards to help you get out of this, and you haven't moved.
I asked him for $3,000 and I would leave. That's what I told him.
Well, that's called extortion.
No, that's for these receipts, all my receipts. Right. I have all the repairs.
All right, well, you can't agree to take money in exchange for something else. Anyway, here's the deal, Ms. Wyrick. This matter is continued until April 28th at 1:30, and we'll have a hearing regarding termination of your tenancy. And he'll bring up his issues and you'll bring up all of yours. I'm ordering an escrow order at $200 per week. If you don't pay the $200 per week, you don't get a hearing. I'm just going to order that you move on April 28th.
I'm moving before that.
If you move before that, it'll take care of itself. Turn in your keys and give your forwarding address within 4 days of your moving.
I need my money for the repairs and my furniture that got damaged.
Then file a lawsuit against them.
Okay.
But on one hand, you want your money, and then you want 13 months worth of free rent. I'm not sure how that balances out. You owe me $3,000. By the way, I haven't paid any rent since March 1st of 2020. That lawsuit's not gonna go very far.
Yeah, but I'm the one that fixed all the other house that I was locked
Okay,
out.
I'm assuming you did, but I don't think it adds up to $11,200.
It's $200 per day for a lockout called conservative eviction. It's $200 per day for locking a tenant out of their home. And I already called Lansing, and they told me to call the police and make the lockout charge, and then the courts will do it. But I see that you're not understanding it, so I'm gonna have to call them and have them help me, I guess.
Well, Tiffany, I've known you since you were just a kid.
Yeah, my mother too.
School.
And
Yes,
my mother.
And I've been a judge for about 18 and a half years, and you're
Yes.
telling me I don't understand the law. It's called a constructive eviction. You haven't even got that right. So it isn't that I don't understand it, it's that you're not in compliance with it. This is, you want to stay there, you believe he did you wrong. Maybe he did. We never got that far. The problem is you've been there all this time without paying 1 cent of rent, and somehow you feel that you've been terribly aggrieved. If you're gonna file an action, file it. Otherwise, we're gonna have a hearing on April 28th at 1:30, and you have to pay the escrow money in the meantime. So I'll see you then. Now, if you move before then, turn in your keys and give him your forwarding address. That may bring this to a close. If you want to sue him for money, go ahead.
So what about the $200 thing you're talking about? Is
You
that
gotta
for
pay-
like?
Yes, now, if you want me to hear your issues, you have to pay the rent while we wait. If you don't pay it, I'm not gonna hear anything you say, I'm just gonna order a eviction order effective April 28th, which would
Oh,
be
that's
10
kind
days
of like
after that.
help him, or the
Well,
money
I
will come
hold,
back to me.
you pay the rent to me, and I
And then
hold on to it, then I'll decide who deserves it. If you
Oh, I
don't
get
pay
it.
it, if you don't pay it, I will simply issue an order on April 28th that you have to be out by May 6th. And if you're out by May 6th, the sheriff will come put all your stuff out in the street.
Yeah.
All right, I've got
Tomorrow.
10 other cases waiting, we've gotta go to those. All right, I'll send you that notice in the mail.
Okay, thank you.
Thank you.
Thank you. Your Honor.
All right, Mr. Larkins, you'll get it too. I don't, well, we'll see what happens. Okay.
I just wanted to be over with, man.
Yes, I think that's probably unanimous. Bettina, you hanging in there?
Thank you.
Yes, sir, I am.
All right. That's a difficult case. It never was a non-payment of rent case. And
Yes.
I've got a 145 civil matter that we've been greatly delayed with our last matter. Good afternoon, Mr. Fleeman.
Good afternoon, how are you?
Oh, I'm fine. We're having a really good time here. And I'm waiting for Mary Jane Elliott's office to log in. I think they're here.
I'm here for that.
All right, good afternoon. This is file 201769, Jefferson Capital Systems versus Mark Ripplinger. File number, as I said, 201769. Ms. Naviat Francis is here on behalf of Jefferson Capital Systems. This is the time and date for a motion for summary disposition in this matter. This is a claim
Your Honor,
for 584.16. Yes?
I'm sorry, this is Elisha Ertman with Deer Creek Townhome.
All right, you're in the right place. I can't
Okay.
see, but we'll get to you in a moment. We're doing another
Oh, okay.
case. If we're here in the
Oh.
courtroom, you could see what we were doing, but we're doing it virtually, and all you have is a phone connection. So you're in the right place, Ms. Ertman. Let me finish this case, and
Okay,
we'll address yours here momentarily. Mr. Ripplinger filed an answer in this case and a previous case. He didn't even sign it. I received notice of this at 3:45 on January 24th. I have no knowledge or memory of this debt. I do not even know who Jefferson Capital Systems or WebBank are. I need to see proof that I owe this money, where the debt originated and when, and how Jefferson Capital acquired the debt. Until I prove proof of this debt, I cannot and will not admit any liability. Well, he filed one of those in an earlier case, and then he didn't appear, and a default judgment entered. In the meantime, plaintiff has filed a motion for summary disposition detailing how this debt came to be and how he owes it. And he isn't here. I gotta make sure I spell this right. I'm glad you spelled it right. I'm going to order summary disposition. I don't think I have a judgment in here. I looked and didn't see one.
They usually do not file it with the motion.
All right. Well, let's figure out how much this is. We have.
Sorry.
Go ahead.
The damages are $584.16. And the court costs are $103. And then there's the $75 statutory attorney fee. So the total judgment amount would be $762.16.
All right. Now here's someone that's joining by telephone. Let's see who this is. We're 20 minutes behind schedule here, which is amazing how bad we've been doing. Good morning. Who am I speaking with?
This is Mr. Dentler.
All right, John, let me give you a name here. I just wanted to make sure you weren't somebody we needed on this case. And I'll give Ms. Ertman a name. Oops. I'm sorry, Ms. Francis. I had to bring him in to make sure he wasn't Mark Ripplinger. All right, you can submit a default judgment. I won't do it as a default. I'll do it as a summary judgment.
Thank you, Judge. Do you want us to do it under 7 day?
That's fine.
Thank you, Judge.
Thank you. I'm glad. Looks like you're on your way from somewhere to somewhere else. I'm glad we could get this accomplished. Sorry we were late, but we got caught up in some other matters. All right, thank you. I'll wait your order and we'll be done. Thank you.
Thank you. Have a great day.
Thanks. All right, Mr. Fleeman is here. We are now only 8 minutes behind, which is pretty good. I've got several people here. I'm not sure who Katie is. Are you here from Deer Creek?
Yeah, I'm the manager.
All right, I've got Ms. Ertman and Mr. Dentler, which are both here only by telephone. We had our previous hearing in this matter on March 19th. The matter was continued until today. Well, let's start with Miss Ertman. She was actually here first. This is Deer Creek versus Alicia Ertman. This is a premise at Cato Lane. The manager, Katie, is here, and Mr. Tyrone Fleeman is here on behalf of the complex. She did start the process at Keystone when we were last here. Bettina Emery from Keystone has been with me all afternoon, bless her heart. Mr. Fleeman, what's the status here?
Your Honor, I'm showing a balance through April, I believe it's April, $2,146. Let me make sure that includes, I'm sorry, that does not include April. That was including March. Let me add to that 784 for April. $2,930 even. And $181.20 of court costs.
Ms. Emery, have you had contact with Ms. Ertman?
Yes, Your Honor. We have all of her documents and she is being processed as we speak.
Does it look like she's eligible?
Yes, it does as of now.
Very good. Mr. Fleeman, what are the other courts doing? There is a COVID stay in effect through June 30th. Normal course of events, I would issue a writ effective date from 10 days from today and not serve it pending the COVID stay, but everybody would have a target date. I don't know if they're putting July 1st as the writ date or what they're doing.
Well,
how would you like?
Well, there's two different things going on. One is the federal moratorium that you're right goes until June, but then also you have the Supreme Court order that says if a tenant has made application with the HARA agency, that essentially the court has to put it out for, and the order is not real clear. It says 45 days, but it also says 30 days for the HARA agency to make a determination if they are eligible, and then 15 more days for the agency to actually pay the landlord. So I think at this point, what some courts have been doing is adjourning it out for 30 days, and to see if it gets handled by then. And Ms. Emery can probably tell better than anybody. You know, will this be resolved in 30 days? Very possibly. It sounds like, you know, the tenant's already done most of what needs to be done.
Would you send me that decision? I'm not familiar with it. We haven't discussed it.
That's not a decision. It was a Supreme Court order. It was, oh goodness. Yeah, I can find it. It'll take me a minute to find it, and I'll email it over to you. But this has been a couple of weeks ago.
Well, obviously I should be aware of that. It was under my radar.
Well, it was an amendment to 2020-17 yet again.
I have 2020-17, but I haven't seen any amendment to it.
And it was issued 3/22 of 21. There you are. Judge, I'm sending it to you right now.
Right.
And there'll be a link in the email that'll go to that. But essentially it says that they're supposed to put a stay on for, and this, like I said, this is where it gets a little dicey in the language. It talks about 45 days, but there's also this 30-day period for the HARA to make their determination. And then
well, she's already started. This is our second hearing, not our first hearing.
Right. And
we already continued it for 3 weeks.
Right.
But she started the process. Bettina, I'm sure you'll be finished with this within 30 days. I'm going to continue this to May 3rd at 2 p.m.
And that makes good sense, Your Honor. I mean, in cases where the parties have already made contact and have already filed the application and it's already working, it makes sense to put it out, 30 days to give time to process. The hope being that the processing and the check gets done before we come back on the 3rd, and I just file a regular good old-fashioned dismissal.
Yes. So, Ms. Erdman, you've held up your end of the deal. You've contacted Keystone. They appear that you're eligible. They're working through the paperwork. I'm going to continue this to May 3rd at 2 p.m. If your rent is paid, the plaintiff will simply dismiss the case. If it is not paid, we'll have further hearing on May 3rd. Do you have any questions?
Okay. No, sir.
Ms. Emery, are you, have you already sent out the landlord application, or have you gotten that back as well?
Let me check.
I've already filled out
Yes,
all
sir. We
that.
have the landlord application. We
You
have
do, okay.
we have all of her documents right here. She's just going through the process of being processed.
Oh, you're in good shape then. Okay, I just wanted to make sure that the landlord side had made its way to you as well. So, all right, we're good. Fantastic, thank you.
All right, thank you. Ms. Erdman, you're good to go. Stay in contact with Keystone. It looks like this may have a happy ending, at least in the short term. All right, thank you. Do you have any questions?
No, sir.
All right, thank you. You're good to go.
All right,
All
thank
right,
you.
Mr.
Have a great
Detler,
day.
are you with us?
Yes, sir.
Okay, good morning or good afternoon to you. We were here on the same date. We were here on March 19th and we continued it to today. It did not appear that you were going to be eligible under Keystone for assistance. Mr. Fleeman, what's the status here today?
Your Honor, I believe I'm still showing a balance of, and I think I didn't add the April rent to this one either. It was $2,125. When I add the April rent to it, $2,814, if I'm doing my math correctly here. Yeah, $2,814.
And court costs?
Are $181.20.
299520. Mr. Detler, what's your position?
Yes, sir. We just got a determination back from Keystone as of this morning, I do believe, and we were denied further help again. So I have a $700 money order I can give to my landlord today, and then my last unemployment check I get is not this coming Wednesday, but the following Wednesday, and I could have $1,600 of that paid. And then after that, it's just up to my wife with her unemployment. But I can make most of my background up rather quickly.
Do you have a tax refund coming?
Yes, it could be between now and August.
Did you get a stimulus check?
I have not received mine yet. No.
Well, Mr. Fleeman, the COVID stay is in effect. He has done his due diligence with Keystone. What's your proposal here?
Well, I mean, obviously the part of that order that I just sent you was the 30 days. I think the stay is conditioned upon them qualifying, and because we know he's not qualified, I wouldn't think that stay from the Supreme Court order would apply. I also don't see where we've received a CDC declaration. At least I have not. I don't know if you have one in your file. I do not have one.
I have not.
So at this point, I would ask for a judgment of possession, giving the standard 10 days to pay.
Yeah,
all right.
If I may, I can have,
just a minute.
I can have most of my. Okay.
Let me tell you some important things. You owe $2,814 in rent through April. plus $181.20 in costs, which is $2,995.20, just short of $3,000. You have 10 days to pay that or you're subject to being evicted. Now let me say this, I want you to listen carefully. They don't have to evict you. 10 days from today is April 15th. They don't have to evict you on April 15th. They have 56 days from today to ask for the writ of eviction. If you, and I did indicate last time they would accept a partial payment. I told the plaintiff they could accept a partial payment. So if you pay $700, then you pay $1,600, that will be close to it. If you get a tax refund or a stimulus check and you pay all of it, then your tenancy is continued and you would owe May's rent in the usual course of business. If you cannot pay it, then you're subject to being evicted. But they don't have to evict you on the 15th. If you say, well, I expect a tax refund on April 18th or 21st, they can wait. What's the holdup with your tax refund?
We had my wife had hers done. I have a separate case of my own going on with my taxes. I have not got my taxes personally done, but my wife has got hers done. She chose to do the 6-month extended to get her taxes back because she was going to get $5,000 if she took it and would have it in 3 weeks. If she waited the 6-month period of time, she could have $11,000 tax return. So she chose to wait the extra, 3 months.
I've never heard of such a
I've
thing, but
yeah, that's what my tax accountant at Jackson Hewitt told me.
all right, well, you got some urgent need for capital to pay your rent, or you live in your car.
And Your
yeah,
Honor,
sure.
Your Honor, looking back at the notes, when we were here on March 19, Mr. Dentler indicated that he had 2 money orders totaling up to $1,400.
Yeah, he told me that.
Were those posted?
Yes.
Kate? Did I not?
No, he didn't give me anything.
So the 14 did not get paid?
No, sir.
That's called
No, sir, I had
a no-show. You had $1,400, now you got none, and you're in danger of getting evicted, John. You really need to get on a stick here.
Yes, I have 700. I'm going to go get and give to Katie today as soon as I get off the phone with you guys. And
All right, that's a
I
good
get
start.
paid not this Wednesday, but the following Wednesday, and I'm going to give her $1,600 on that day.
All right.
My goal is to have my total rent paid up, squared, and dead even by the 28th of this month.
Well, you got till April 15th. If she agrees to give you the 28th, that's allowable. All right. If you do move, you need to turn in your keys and give your forwarding address within 4 days of moving. Mr. Freeman's going to submit a judgment, and I'm going to sign it. All right. Good luck, Mr. Dentler. Stay in contact with your manager.
All righty. Thank you so much.
All right. Thank you.
Your Honor, I'll go ahead and prepare that judgment and send it in right now.
All right. That completes your obligations.
That's all I have case-wise for today. But
Well, I have
can we go off record for just a second?
It's hard to.
Is it? Okay. I was just going to tell you that my brother lives in the Indianapolis area, and for some reason his wife went to do a search on my name, essentially to show one of her coworkers what I look like. And what do you think would come up in Indianapolis, Indiana when you search on my name? It would be a video to the 3B District Court room in Centerville, Michigan, because you are so popular in the ether that your cases rise to the top of the hit list off of a Google search.
I'm in the ether, all right. Well, anyway, what was her reaction when she saw what you looked like?
Well, her coworker happens to be African American, and she mentioned my name in passing, and he asked if I was a black guy, and she said no. He didn't believe her, so that's why she was looking my picture up. And you'll be more interested to know that the first thing my brother says is, "Are you coloring your hair?" No, I'm not coloring my hair. So that was
I'm in no position to comment on anybody's hair. So, all right. Well, thank you. I'll get on to our next batch of customers here.
all right. And I did send you that email with that list for the amendments.
I do appreciate that. I'm a bit embarrassed that it got under my radar. That's been 4 working days, and I don't remember seeing it. I'll look at my emails.
But,
all right, thank you.
But what you're doing is the right way. Kick it out for 30 days. When you've got, Miss Emery and people like her on top of the file, then yeah, let's you and I get out of the way and let them do their thing. And so I think you're handling it the right way. So,
all right. Thank you. Bettina, I've got a bunch of people in the waiting room here. So let's bring them in. Some of them are other issues. We're actually almost on time.
All right. Can everyone hear me?
Yes.
Yeah, sorry, just a moment.
Oh, you're fine. Got it.
All right, I've got Emmanuel Espinoza. He's not set till 3 o'clock. I've got Stacy Bowles. She's not set till 3 o'clock. And so, Ms. Bowles, can you hear me?
Yes, Your Honor.
You're early. I'm going to put you in the waiting room, okay?
That's fine. I just wanted to make sure we didn't have any time.
You're welcome to watch. If you want to watch, I'll just mute your microphone.
Sure.
We're doing.
Sure, that's fine. Thank you. Thanks, Your Honor.
And Mr. Emmanuel, same thing. I'm going to mute your microphone. He's not ready yet. And then we've got a phone number. Who is 269-625-8809?
It's Chantal. Chantal
All right.
Carver.
All right.
I'm sorry, it's a new number, sir.
You sure you don't hit share screen? Okay.
All right. It's hard to keep everybody lined up at the same time at the same place. The next case actually on our schedule is Kreitz Rentals versus Volk and Andrews. Are you Brian Volk?
Yes, Your Honor.
Is Alexis Andrews with you?
No, Your Honor. She no longer lives here.
All right. And Ms. Feaster is here. I'm going to read you guys no, this is a second hearing. We'll just go to Volk. We were here on March 22nd. He indicated that April had moved to her grandparents after the child was born, and he's there by himself. The matter was continued. He was going to contact Keystone. Mr. John Bush is here for the plaintiff, and Mr. Jamie Kreitz, the landlord, is here. Mr. Bush, what's the status here?
My understanding, the only change is the back rent's now $3,500 because the April rent came due.
Ms. Bettina Emery is here from Keystone. Bettina, do you have any input on this case?
Yes, we are currently in the process of getting the tenant application from Mr. Beck. We do have the landlord application and we're just waiting on documents.
All right, Mr. Bush, we just had a discussion with Mr. Fleeman, who was here on our earlier case about a new directive from the Supreme Court that I haven't seen it. But it recommends we extend 30 days, which would also include May's rent. And Mr. Kreitz, I'm sure you're concerned about that because we get into another month's rent.
Yeah.
But he has started the Keystone process, and so I'm going to continue this to May 3rd, 2021 at 1:15 p.m. John, does that work for you?
Hold on, Your Honor. That would work, Your Honor.
All right, now, Bettina is working on this one, which is a piece of good news. If the matter is resolved and the rent is paid, and there's a consent dismissal or something, nobody needs to appear. If not, we'll have a hearing. The order from the Supreme Court says we're supposed to give 30 days to allow Keystone or other HARA agency to do their thing, and possibly another 15 after that. As a practical matter, there's a COVID stay until June 30th for non-payment of rent anyway. So the rules keep changing and the target keeps moving, but Keystone is involved here, and my hope is Mr. Peak will get his rent paid, Mr. Kreitz will be made whole, and we'll move forward from there. We'll continue this till April or May 3rd at 1:15. Stay in contact with your landlord and stay in contact with Keystone. If the rent is paid, nobody needs to appear. If the rent is not paid, we'll have a further hearing on May 3rd. And I'm hoping Bettina works her memory and magic in the meantime and rent gets paid. All right, do you have any questions, sir?
To Jamie or myself?
To you.
I just finished the application. I'm going to need help from Tina getting some of the required paperwork and documents that they need for the application. But besides that, the application's just been finished. I'm going to be turning it in today. I just need help with some of the paperwork.
All right, they'll do that. We got 30 days to get it done.
All right, thank you, Your Honor.
Okay, I have another movie here. All right, in the middle of an already busy afternoon, I crammed in this because Mr. Bush and Mr. Kreitz were scheduled to be here. It's entitled Kreitz versus Chantel Carver. The file number is 21297LT. This started out, there is a lease that was from April 23rd of 20 to April 23rd of 21. The plaintiff filed an application to terminate the tenancy. And then we had a consent order for conditional dismissal in December. And the defendant was to vacate or be subject to a writ of eviction, or she was to pay. Then in January, Mr. Bush asked for an eviction order, which I signed January 11th. Then we started all over again. In February, demand for possession due to health hazard. And that was filed in February. Ms. Carver was personally served with that. It was set for hearing on a termination of tenancy on the 12th of March, and the defendant did not appear. So I issued a writ of eviction effective March 22nd. Mr. Kreitz was prepared to request a writ of eviction, in fact did, I think, and the defendant wrote this letter saying, I don't know where to go and I haven't moved yet. And please let me have a stay for a while longer so I can save some money. Ms. Carver, they've been trying to evict you since last winter. We had a conditional order of dismissal that didn't work. Then they moved to terminate your tenancy. You didn't show up for the hearing and I issued a default judgment.
I was really sick, so I'm sorry.
All right. How hard is it to call on the telephone?
Sir, I was in and out of consciousness with a fever them 2 days.
All right. Well, at any rate, you didn't appear and the default judgment entered. So you have to have a legitimate reason for failing to appear and you have to set forth a meritorious defense. I don't know that there is any meritorious defense. Mr.
How is me not being sick? I'm sorry.
Mr. Bush, what's your position?
We want to go forward, Your Honor, with the eviction. I mean, we would give her 15 days for entry of a writ, obviously, to give her an opportunity to relocate.
Chantel, what do you say to that?
No, that's okay. It's going to happen anyway.
Yes, that's very generous. Because it could happen today. Jamie, you agree with those terms?
Yes, Your Honor.
All right. Mr. Bush, you can submit an order. Writ of eviction may enter 15 days from today is April 20th. By consent. If you're not out by April 20th, Chantel, the sheriff's going to come put you out.
Yes, I know, sir.
So that your landlord gave you that extension, and I'm glad we could set it at a time he and his lawyer were both set to be here. 15 days is April 20th. Move or writ?
Can we make it the 22nd? So I've been here a year, sir. Kind of ago.
No.
Okay.
All right.
Thank you anyway.
All right. Thank you. And then
So
when
you want me to
move,
submit another judgment then, or what document do you want?
well, there's a judgment, yeah, an amended judgment with the date of April 20th.
Okay.
For the writ.
We'll do that.
That'll be more clear to her. You do have, theoretically, 10 days to appeal this, or this is a consent judgment, so let me read you the language. The judge, if you do reach a consent judgment, what this is, the judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. All right, Ms. Carver, if you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving.
I'm probably going to be homeless, but I won't have an address.
Well, I don't have an answer to that. He's been asking you to pay or move since last November.
Sure.
So, anyway, he's granted you 15 additional days, which is extended from the 12th of March to the 20th of April. It's about 40 extra days. Hopefully that will work. All right, you're free to go.
Thank you.
Thank you, Your Honor.
Thank you. We lost Miss Feaster. We'll bring her back. Thank you, Mr. Kreitz. Feaster is set for 2:30. That puts us 9 minutes behind schedule. Lance, if you saw the kind of day we were having, you'd be amazed we're only 9 minutes behind schedule. Now, I have another customer who's in the waiting room. Let's see, two telephone numbers only. Those are the most difficult. Find out who they are.
Oh, yeah.
Good afternoon. Who am I speaking with? 269-873-4211.
Hey there, this is Shilpa Alwine.
All right. Thank you. All right, I got another phone number. Good afternoon. Who am I speaking with?
Bailey Cunningham.
All right, Mr. Cunningham, let me give you a name. And we've got Nicholas Sensat, who I think is a small claims.
Actually, he's on my case, Your Honor, for Sturgis Place.
All right, good. Oh, and I've got another phone number. Oh, boy. Good afternoon. Who am I speaking with?
Hannah Green.
Good afternoon, Miss Green. Do you have the ability to do video?
I don't have the Zoom app on my phone. We don't have Wi-Fi where we live, so it doesn't really work.
All right, well, stay where we are. This is Judge Middleton. I'm over at the courthouse in Centerville, and we will be with you in a bit. We have a number of people here. I'm going to tell all of the tenants that you have the certain rights under the landlord-tenant law. So I might as well do this all in one fell swoop here. I think it's fell swoop. As a defendant in a landlord-tenant proceeding, including non-payment of rent, termination of tenancy, land contract forfeiture, mortgage foreclosure, or other action, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, the Michigan Department of Health and Human Services, in our case it's Keystone Place, or other federal agency may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. The summons and complaint are sufficient. If the plaintiff is agreeable, the Citizens Mediation Services may be available as a possible source of case resolution. You can call the court and we can facilitate scheduling that if the parties are agreeable. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. If the judge does not find in your favor, the original judgment will stand. The next case on our schedule, we still have quite a few to go, is Sturgis Place Apartments versus Feaster. Miss Erica Feaster is here, and I believe James Feaster is also with her. We were here previously on March 22nd, and Bessie Klaus was, I think, the defendant's mother or grandmother, I can't remember, and Erica had contacted Keystone. Bettina Emery, our housing advocate from Keystone, is here with us. Bettina, are you plugged into this case?
Yes, Your Honor, I am. They have sent in all the required documents. They are eligible, and we are in the process of getting their application approved.
Lance, what we did in the last couple of cases, Tyrone Fleeman was in on an earlier feed, and we discussed what they're doing in other counties. There's a new amendment to the original rule from the Supreme Court, which he says was issued March 22nd, which recommends we adjourn these 30 days to allow Keystone to facilitate the paperwork. In addition, there's a COVID stay in effect, if they request it, until June 30th. So what I've been doing with these Keystone places is continuing them 30 days, which also include May's rent, which would take us out to May 3rd. It does sound like they are eligible. The paperwork is in the works, and it may well result in a dismissal before May 3rd. But that's what I did with the last couple of these before you checked in. What's your position on that?
If I could ask Maria, Your Honor, Maria, have we received CDC declarations from these two defendants? You're muted, Maria.
No, we have not received CDC declarations from them.
All right. So are you going to ask for a 10-day order?
Yes, Your Honor, until we get the CDC declarations.
All right. Well, we will assume that rent is, I'm going to reduce these late fees to 40. Take $70 off of that. 2470. The rent is 2470. We haven't added in April, so we need to add another $885.
The judgment information sheet dated April 5th, if you've got that, should have April's rent in it. I sent it over this morning.
Yes, you did. Here it is. I had the old one. Well, wait a minute. Yes, I've got it. Lupita gave it to me. Still, we're going to take $70 off. 2,515. $2,515 plus court costs of $179.52. Hopefully, Bettina can pull a rabbit out of the hat and get this done within 10 days. $2,694.82. That, if it's paid, and I suspect they may pay your rent through May, then the case will be dismissed. If it isn't paid, you're subject to being evicted on or after April 15th. I've got a judgment here before me. Now, they don't have to evict you on April 15th. Rent is $2,515,179.82 in cost, total of $2,694.82. But Tina, I'm gonna have one of these sent over to you, all right?
Okay.
The judgment. I'll indicate send judgment to Keystone.
What is the CDC thing you guys was talking about?
All right, there's a federal government has said that if the people request a stay of eviction, the landlord can't evict somebody for non-payment of rent until after June 30th. This has been going on for almost a year. On every 30 days, it expires, and then they renew it. But you haven't filed a request for a stay of eviction. You have the right to file one. You can look it up on the internet. And then they wouldn't be able to evict you until April 15th, but you have to make a good faith, till July 1st. You have to make a good faith effort to pay the rent. But it sounds like Keystone's gonna cover your rent, at least through May. And I'm not issuing a money judgment here. So it's very important you stay in contact with Keystone and with your landlord. And you can look up the CDC stay online, how to file a form. But if your rent is paid, that may become moot. Do you have any other questions?
No, that was it.
All right, you're good to go. Stay in contact with them, and hopefully your rent will be paid and you won't be subject to being evicted.
Okay.
All right, very good. You're free to go. Now, Mr. Sensei is here.
Yes, sir.
Nicholas Sensat and Helen LaForce are here. They have not filed a CDC declaration. We were also here on March 22nd, and Keystone was involved. Ms. Emery, what's the status here?
Unfortunately, they do not qualify because their income exceeds our amount.
Mr. Sensat, what's your position here? When we were here before, you indicated you had started the process. Rent here is, again, I reduced it. They were charging a late fee of $100. I allow 40. 60, 60. So it's 240 reduced through March. No, he sent me a new one. Here's the one through April. 1, 2, 3. 1, 2, 3. The other one had 4 late fees on it. This one only has 3. So they took the December late fee and the January late fee out of it. Are those removed?
Yes.
All right. So we got 3 late fees, so minus 180. 5779. 5599. Through April, they allege your rent is 5,000. Whoops.
That's correct, 5,599.
Just a minute, I hit something and knocked myself out. There we go. Plus court costs of 205.52. 594. Equals 5,008.04.52. It's a lot of money, and you're not eligible for assistance, which I regret to inform you. What's your position here?
Today's truth, I'm really not sure, Your Honor.
Well, let me tell you some things I told the last people. You have not filed for a stay under the CDC moratorium on eviction for non-payment of rent. You can look it up online, but there's a form you can fill saying we are requesting that we not be evicted pending the COVID stay. You haven't asked for that, so I'm going to grant this order. You can file it, and I would recommend that you explore that. You're almost $6,000 behind on your rent. You're not eligible for any emergency eviction diversion funds, and they want you to move. That's a bad position to be in.
Yes, sir, it is.
But I'm going to use the figures I just did. $5,599 in rent. 205.52 in costs, which is 5,804.52. I'm not sure why you're not eligible. I don't make those eligibility decisions, but I think you were hoping that you would be. Bettina, are they eligible for any other program?
They would have to contact their local 211.
All right, that would be the Community Action Agency?
Yes.
All right, you may consider that, but I think you're going to have to move, is what I think. But if you file this COVID stay, they may not be able to evict you until July 1st. But right now I'm using the date of April 15th, which is 10 days from today. You also have 10 days to appeal this. I'm not issuing any money judgment at this time. If you do file for the stay of eviction, you need to take that up and give it to your manager, Maria, sooner rather than later. And then during that period, you have to make a continued effort to make a payment, but you're very far behind, and it doesn't sound like there's going to be any emergency funds. The other thing is there is another agency called the Community Action Agency. Do you have their number, Bettina?
No, sir.
All right, I don't have it in front of me. Who may be available to provide some emergency help, but they have limited funds. So 3 things. I've told you have to pay $5,804.52 by April 15th, or you're subject to being evicted. It's when the sheriff comes and puts your stuff out. However, if you file the emergency COVID stay before the 15th, it could stay the ability to evict you until after June 30th. Secondly, I'm advising you to contact the Community Action Agency for St. Joseph County and see if they can help you. Or thirdly, you just need to move. And if you do move, you need to turn in the keys and give your forwarding address within 3 days of your moving. Do you have any questions?
No, sir.
All right, you're good to go. Thank you.
Thank you.
All right, we're coming up on 3 o'clock at our convergence of a number of things. We aren't done with our landlord-tenant cases yet. We have Sunset, we have Allwine versus Green, and then we will take up our 3 o'clock matters. Those people are waiting in the waiting room, and for right now, we'll just leave them there. Hannah Green, can you hear me?
Yes, sir.
Mr. Paul Gibson is here on behalf of the plaintiff, who is Mr. and Mrs. Allwine. This was a hazardous situation. The landlord contends they were threatened by the defendant. They've had no rent since, I think, no rent for March. The parties were trying to move out, had their stuff packed. Miss Green, what's the current status?
We are actually getting a U-Haul and moving. We would have been
Will you be out by 10 days?
Yes.
Do you know where you're moving to?
Yes, we're moving to Constantine in the trailer park.
All right, when you move, you need to give your landlord your address in writing, within 4 days of your moving. Mr. Gibson, I don't believe I have a judgment. Could you email me one?
Yes, I can. As far as the money judgment, that's reserved for later on, is that correct?
Yes, correct. Once they move out, you take possession of the premises, you can determine the condition of the premises and file a separate action for money damages. Now, Mr. and Mrs. Green, you agree, or Mr. Green and Mr. Cunningham, you agree that if you move and turn in the keys, that would finish this case. So this is a consent. If you do reach a consent, which this is, the judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment will stand. Do you understand?
Yes, sir.
Yes, sir.
All right, you agree to move by
Yes,
April 15th, or you're subject to being evicted.
Which date is that?
April 15th.
April 15th.
10 days from today. Or let me repeat something else. You need to turn in your keys and give your forwarding address within 4 days of your moving. You need to do that in writing.
Okay.
And we're not ordering that you pay any money. Once you move, the plaintiff will take possession of the property, and if they ask for money damages, you'll be served with a new summons and complaint, and we'll have a hearing where people will be placed under oath and figure out who owes who how much money. This is called a possession judgment. You simply have to move within 10 days. Do you understand?
Okay. Yes, sir.
Yes.
All right. Thank you. Mr. Emmanuel, you're on a live Zoom hearing and people are watching you pick your teeth in the course of this hearing, so you need to conduct yourself as though you're in a court hearing. That's something you wouldn't like. All right, Mr. Gibson, anything further?
Do I need to check box number 7 on the judgment?
Which is?
It says no money judgment is entered at this time.
That's correct. You don't check it, I will.
Okay.
All right, thank you. All right, I'm gonna remove Ms. Alwine. Just email that judgment and I'll sign it.
Okay, thank you.
I'm gonna remove Bailey Cunningham, who was here promptly.
I had a question too, Your Honor.
What's your question?
We're trying to get a court-appointed attorney because we can't find anybody that would deal with our case at hand.
We don't have court-appointed attorneys for civil cases. You have, I told you before, you had a right to contact legal aid. But, so are you agreeing to move or not agreeing to move?
Yeah, we're moving. I just
all right. When it gets to the money portion, you contact legal aid again to help you in that case. Right now, as long as you move and turn in the keys, you'll be all right. Okay. All right, thank you, Ms. Green. All right, now we have a new batch of people to bring in here. Thank you, Mr. Gibson. It's 3:05. And I got a bunch of people who are telephone numbers only, and those are always difficult. So let me bring those in. All right, I've got people I've got to bring in. So you're logged in as Tina. What's your name, sir?
Dean Fisher.
All right, let me give you a name. Whoops. If I could spell, I'd be all right. All right, give me a moment. I've got 3 people that are here by telephone number only, and I've got to discern who they are one by one. Good afternoon. This is Judge Middleton. Can you hear me?
Yes.
No, Mr. Fisher, you just stay quiet. This is my next person, who's just a phone number. Can you hear me? 517-888-4212?
Yes, I can.
What's your name?
My name is Courtney Quintero. I'm with Consumers Energy. I'm here training. I should be with Jody Leach from Consumers Energy as well.
Jody is here, but let me give you a name rather than a telephone number. What's your name again?
Courtney. My last name is Quintero. It's Contero.
All right. Stay right where you are. I've got 2 more people to bring in as telephone only. Good afternoon. Who am I speaking with?
This is Susan at Warner Oil Company.
All right. I don't know why you guys don't have videos, but let me get you in here, Susan at Warner Oil.
Okay.
I'm not worried about color because I'm going to use the body shop you painted.
What's your last name, Susan?
Denison, Denison.
All right, thank you. Let's spell your name out. D-E-1-N. All right, and then we got one more phone number. You guys can't see me, and I can't see you. I look really good, so I wish you could see me.
Well, I'm glad you do.
That's a matter of opinion, I guess. We got one more person we're bringing in here. 269 279189. Who am I speaking with?
Marissa Peck.
All right, let me give you a name. All right, I think that's everybody that's here. We're in the middle of landlord tenant docket. At 3 o'clock, we set some small claims matters and another matter. So we have Emmanuel Espinoza, who is here, and Kevin Carwat, who doesn't appear to be here. We'll come back to that one in a minute. Although I don't think we have any service in that case. Then we have Consumers Energy versus Dean Fisher, and both parties are here in that case. Then we have Stacy Bowles versus Alan Yoder. Stacy Bowles is here, Alan Yoder is not. And Natasha Wyeth. Let me set that one aside. We have Warner Oil Company versus Marissa Branham, and you're now Marissa Peck.
Yes.
All right, let's start with that one.
Okay.
This is an asset discovery hearing. Ms. Branham, now Ms. Peck, Warner Oil Company sued you in small claims court, and they got a judgment against you in the amount of $5,473. You consented to that judgment. You're going to pay $225 per week beginning July of 2018, and apparently did not pay. So they've served a subpoena on you to subpoena you to come to court to discuss your ability to pay on this debt. And this is set for what's called a discovery hearing.
Okay. Can you hear me?
Yes. Give me a minute. You can't see me. I'm making some notes. I'm going to put you under oath. Ms. Peck, would you raise your right hand wherever you are?
Yes.
Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yes.
I'm going to put you in what's called a breakout room with Miss Dennison of Warner Oil, and she's going to ask you some questions, including your social security number, employment, bank accounts, vehicles, that sort of thing, determining your ability to pay or work out some other agreement. I'm going to put you both in the breakout room. If you wish to come back, simply come back in. If you conduct your business and you don't need any further assistance from the court, you're welcome to just hang up. But I'm going to put Ms. Peck and Warner Oil in a discovery hearing.
Then how do we come back?
If you don't come back, hang up and log in. All right, we're plugging along here. Ms. Bowles, you've been waiting patiently watching our landlord-tenant proceedings. This is Judge Middleton. We've met before, but
Yes,
you're
Sean.
here today on your small claims matter. Would you raise your right hand? Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yes, Your Honor, I do.
All right, this is Stacy and Mark Bowles versus Alan Yoder and Basha Nicole Wyeth. Neither of those parties are here. Let me explain to everybody that is here that we are in the small claims division of 3B District Court. If it's a separate division of the court, the rules are different. The claim can be up to $7,000. Neither party is allowed to have an attorney. There's no formal record being made of a small claims proceeding, although we're presently live on YouTube. There's no appeal from small claims. Any decision made there is final. Ms. Bowles, you filed a claim for $3,290 against Mr. Yoder and Ms. Wyeth, and you provided pictures of the damage they did to your premises. She was served by certified mail and he was served by certified mail. Neither one of them are here, so they're subject to a default. Now, let me see if I have a judgment.
Your Honor, I think the amount's $3,383.14, I think.
Well, what I show, let me look. The claim that was filed on January 14th.
You're right, I'm sorry. You're correct, I'm sorry. I've got so much paperwork here on this case, I'm so sorry.
All right, $3,290.84. I think my judgments have just arrived.
I was wondering if I forgot.
All right, thank you. Thank you. They're subject to default. So they owe $3,290.84 jointly and severally, plus $81.15, which is $3,371.99. They have 21 days to pay that, or they're subject to collection, like garnishment of wages or other things. You can ask for a discovery hearing like the other defendant did, or other plaintiff did. I've signed the judgment in that amount by default. Now it's jointly and severally. So if you can collect all from Nicole, fine. If you can collect half from each, fine. But you can collect the entire amount jointly or severally from either defendant. Ms. Bowles, do you have any questions?
No, Your Honor. So I wait for the 21 days. If I don't hear from them, then I just file the discovery paperwork?
Yes. Yep.
Okay. Excellent. Nope,
All
I have no
right, you
questions.
got to watch some Landlord Tenant in there.
I did.
Oh, that's very bad. All right, thank you. That completes
Thanks, Your
that.
Honor. Have a great day.
All right. Mr. Espinoza, can you hear me?
Yes, I do.
All right, good afternoon, sir. Are you Manuel Espinoza?
Yes, I am.
Would you raise your right hand? You swear or affirm any testimony you're about to give here will be true to the best of your knowledge or belief?
Yes.
All right, this is a claim for $5,000 for a repair job that was done by Got All Auto Parts in Bay City. They have not been served, so I can't do a default judgment against them until I confirm that they have been served. The last case, I did a default, but the people had been served by certified mail. So I'm going to adjourn this. Continue for 30 days. I'm going to continue this to May 10th. At 3 p.m. I can't do a hearing unless I can prove they got service, meaning they know about the hearing.
Okay.
I can't default them if they didn't know they were supposed to be here. So we'll try a little more than 30 days to get service. They got sent by first class mail, but that's not good enough. I either need personal service, posting, or certified mail. We will retry certified mail or personal service. Do you have any questions?
No, I do not.
All right, we're going to adjourn this. I'm not dismissing it. You don't have to start all over again, but we do have to try to get service on them. If we can, then I'll hear your claim for damages to the damage to your car. All right, Mr. Espinosa, thank you for waiting. You also got to watch a bunch of landlord-tenant stuff.
Thank you.
But it is a public courtroom, and you're welcome to be here. Okay, I'll just move him. We are trying to stay on schedule, which is, oops. Not always easy to do. All right, this matter, we got two people here from Consumers Energy. Where is Courtney Quintero? Oh, there she is. What's up with that? Courtney, are you still there? Miss Quintero? Oops. Mr. Fisher, can you hear me?
Yep.
All right, Miss Quintero is back and Jody Leach is back. So will all three of you please raise your right hand? Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief?
Yes.
Yes. Yes, I do.
Yes.
All right. This is a claim by Consumers Energy for money damages in the amount of $4,419.91. They allege that you, I'll read it as it's written, caught down ground on Consumers Energy transmission electric pole, causing damage on October 12, 2019. Cost of repair was $4,419.91. They had some trouble getting service. We do have it now. The defendant was served and filed an answer. I did not cause damage. That ground wire was loose from that pole for years. I told them many times to fix it. There's a lot of money at stake here. This was 2019. They've been trying to get service for some time. Miss Leach, what's the circumstance here?
Yes, what I have here is the farmer, Mr. Fisher, caught, it's a down ground that goes next to the pole. He caught that, I assume, with a piece of his equipment on our transmission pole, and it caused damage to our pole on the transmission side and our distribution side. And that's what these costs are. Now, I spoke to Mr. Fisher shortly after we invoiced him, about 5-6 days afterwards. And he never mentioned anything about previous damage, and I have no record of any previous damage to that pole. He was disputing costs and said he would talk to his insurance carrier at that point, and I never heard back from him. I made a couple of phone calls to him, but he never returned my call. And I have pictures kind of showing what the damage was.
Oh, I have the pictures. How do you know he did it?
Our crews, are the ones that gave me his name and stuff, and he farms that field there, and he never did dispute that he did the damage. He just disputed the costs.
Miss Quintero, do you have any knowledge about this?
I do not, Your Honor. I'm in training for this position, so I'm listening in on the proceedings.
Very good. Well, all right. Mr. Fisher, do you acknowledge that you caught this guy wire to a transmission pole?
No, and it's not really a guide wire. It's a ground wire that's supposed to be fixed right to the pole.
This is a civil case, and in a civil case, the plaintiff has to prove the case beyond a preponderance of evidence. I used to be the prosecutor for many years, and the prosecutor had to prove things beyond a reasonable doubt, which is hard to do, particularly when trying to convince 12 jurors that somebody did something beyond a reasonable doubt. That's a very high standard. Preponderance means just barely more than the other side. But everything that Miss Leach knows is secondhand. She doesn't have any firsthand knowledge about what happened. And so we've got a bit of a disadvantage. They say you did this and they sent you a bill and you didn't pay it. So even though they only have a preponderance burden, they still are the plaintiff. They have to meet the burden of proof. Her story is somebody told me that you did this and we sent you a bill. We don't know who those people are. We have some pictures here. We don't know who took them. And I'm not exactly sure what the deal is. So, Mr. Fisher, maybe you can enlighten me here.
As far as what is your exact question?
You said you didn't do it. What happened?
Well, I don't know. I got a bill in the mail and I called them up and asked them about it. And then I wondered, if you're just fixing a ground wire, which is just fixed to the side of the pole, why would a bill be $4,000? That just seems astronomical to me. I don't understand it.
Now you're under oath. Did you catch that wire with a piece of your equipment?
No, I did not.
Do you know what happened to it?
I know that wire's been loose for years and years because there was a crew in that field. I'm not sure how many years ago, but I pointed it out to them exactly then that it's been loose and hanging there forever because they replaced a pole and drove all over my soybeans. And I remember distinctly because they gave me a card for me to collect damages. And 3 years later, I finally got pennies on the dollar compared to what my soybeans were worth. And they still didn't go over and fix that wire. There's only 2 poles from the pole they were working on. They said they had to call it in or get a separate work order or something. I don't know, but it doesn't make much sense to me.
All right, well, Ms. Leach, can you help me with any other information you may have about this?
Well, one thing I'd like to point out is I didn't receive his answer until Friday. And if I would have known he was disputing it, I would have had the serviceman on this call. But I didn't know till Friday, and I wasn't able to get him on the schedule to, especially with Zoom, it's harder now with our field personnel.
Well, it's harder and easier. They don't have to come over to Centerville, but what it says is farmer caught down ground on an HVD pole. It broke the standoff arm, ripped it off the pole, and took out X-phase and the underbuilt high decker. Was called in to make repairs as the ground was only 10 inches away from the 46-inch phase. I don't know what that means.
Would you like me to explain some of it?
Well, I'm not sure. He says, he's under oath, he says, I didn't do it. Something happened. This didn't just happen in the wind.
Right.
So let's assume somebody did do it. Well, we have to have some proof it was him. Did he ever admit to you that he did it?
Well, I talked to him on December 19th, 2019. And my notes say, and I remembered the conversation, that he was disputing the costs. And he said he'd review it with his insurance and get back with me. Then he never did. So I called back on August 17th, 2020, and left a message for Mr. Fisher And just to let him know, I haven't received payment yet from his insurance carrier, and I never heard back from him. So in my mind, I mean, he wasn't disputing that he had caught the wire. He was disputing the dollar amount.
Sergeant Morse had a good deal of trouble trying to serve him. All attempts at this Fairfax Road address, dog in driveway barking and growling, white male 50 sitting inside the house looking out the window, attempted to approach the door and the male opened the window and said nothing. The dog was still growling. He said Dean Fisher was not there, didn't know when he would be back. Confused when I asked his name. Said I would leave a card and he said leave it on the sidewalk. I left a card on the door, no answer. Left a second card on the door, no answer. Called on the phone multiple times, got an answering machine, no one returned a message. Showed that was the address for Dean Fisher. He filed his answer. It was date stamped March 22nd. March 22nd was Monday a week ago. So that's, I'm not sure, when did, and he's supposed to serve a copy on you. How did you get the answer?
I got it through first class mail.
From him or from the court?
Gosh, I should have saved the envelope. I don't remember. I thought it was the court because I remember seeing 3B district court on the return. Yes, so
right.
It's from you.
All right. Mr. Fisher, did you send a copy of your answer to the plaintiff? Or
No, I
send
just read it, the way it said was to answer it in court, so I walked into the courthouse and answered it there.
Okay.
And also on our conversation with Consumers Power, I told them then, I said, I didn't hit that wire. It's been hanging there for a long time. And there's no reason to blame me for someone else's maintenance. I don't get to bill people for my maintenance.
All right, I'm going to continue this to allow you to have some witness that will testify about what this damage was. Now, let's assume someone testifies, well, it got yanked off of there. There's still not evidence that Mr. Fisher is the person that did it. Is this on your property, Mr. Fisher?
Rented property.
It's on property that you rent?
Yes.
Who owns the property?
Farmlands owned by Dick and Diane Denny and Gary Decker.
I don't know if there's a witness that saw him do it, or he said to a technician that he did it, or one of the people that owns the land knows he did it. But right now you don't have enough ammunition to prove that he did it. He didn't send you a copy of his answer. It had to come to the court. Then we had to process. We had to send it. Last Friday was a court holiday. Court was closed, but I believe the mail ran. So if you got it Friday, you may not have even been opened. So I'm going to continue this to May 10th at 3 o'clock. If you can provide witnesses that can say he did it, then we can talk further about what was what. if you're just proceeding on what someone told you, that this got yanked out and they assume the farmer did it, and he got a bill for it, you're not gonna be able to sustain your case. But if there's some evidence that he did it, and then we'll determine how much it costs, but he stated under oath he did not do it. So we will proceed. Mr. Fisher, do you have any idea how it did happen?
Well, I don't know what it is. I just know it's been hanging there forever. So.
All right, so you didn't do it and you don't know how it got damaged.
Well, I think it's been damaged forever. It just, all of a sudden now they decide to fix it, or it had a problem with it, but I don't know. It's been so forever long that I've seen it hanging there that I can't even tell you how many years it's been hanging there.
Well, something happened because it shut the power off and they had to go fix it. But so I'm just trying to get clear. A hired hand or someone, your son or someone that farms with you, they didn't run over it either? You have no knowledge of what happened to it?
No, that's what I mean. I was the only one in the field that fall, and I know I didn't do it. So I don't have to get close to the poles. I keep them all trimmed up nice, no weeds around them, no brush, no nothing. I keep everything spick and span, so there's no reason to get that close to them.
All right. Well, they have to prove it. So saying it and proving it are two different things. It's part of the process. Anyway, I'm going to allow you to get other witnesses that may have some direct knowledge about this. We'll continue it to May 10th at 3 o'clock. Sergeant Morse had a lot of difficulty serving you. We'll just send you a first-class mail of this.
I got it written down too.
All right. It'll be by Zoom like this once again.
Be the same address?
Yes. I'll still be here by then. All right. Do either of you have any questions?
Your Honor, I have one question. If my serviceman does not have firsthand knowledge that Mr. Fisher caused the damage, then I would dismiss the case, is that correct?
Yes, you can send in an order of dismissal, or you can show up that day and do it.
Okay. Well, I wouldn't want to make Mr. Fisher attend if I couldn't prove my case, so I just wanted to
Fair
confirm
enough.
that.
So yeah, if you did, you can send an order of dismissal.
Okay.
All right, thank you. Mr. Fisher, thank you for waiting. You also got to watch a little landlord-tenant court. We're a public proceeding. We're not ashamed of anything we do here. We do it all and people are free to view it. So you got a little court exposure today, but we'll continue this to the 10th of May. If they determine they can't prove it, they'll dismiss it and you won't need to come back.
Okay.
All right, thank you.
Thanks.
Okay.
Thank you.
Thank you.
Thank you.
All right, I'm going to move Ms. Contero. I'm going to remove Ms. Leach. All right, I've got several other people waiting here. We've got a ways to go. We have 330 Riverside and Van Dyke, Walton and Robinson, and Maple Crest v. Patrick. So we have 3 more to go. We're not doing too bad. Give me just a moment. I'll take these small claims cases out and we'll resume where we were. right, Bettina, we're on the home stretch here. I've got some phone numbers again, and it might be those people from the discovery hearing, I fear.
Hello,
Yes, who am I speaking with?
this is Kathleen Van Dyke again.
All right, just a moment. All right. Oops. You're bringing the other party. Good afternoon. Is this Miss Pack? Who am I speaking with?
Anthony Robinson.
All right, Mr. Robinson. Thank you. I got to bring in a couple more people here.
Okay.
Miss Van Dyke, which case? Oh, you're here on Riverside Place. All right.
You want the case number?
I've got it here. Thank you.
Okay.
This is Judge Middleton once again. We are 11 minutes behind schedule, which is amazing considering how many cases we've done today. But let's say what we have on our plate right now. We have a Maple Crest Apartments versus Taraya Patrick. That's set till 4. She's not here yet. We have Walton v. Robinson. Marcus Walton is here. Lori Hines, his attorney, is here. And Anthony Robinson is here. Then we have Riverside Place versus Van Dyke and Roomvelt. We're going to take that one first. It's a non-payment of rent case. Ms. Graves, are you here from Riverside Place?
Yes, I am.
All right. Ms. Dana Hull is here on that case. All right, this was a non-payment of rent case. We made some calculations last time that rent was $1,970 with costs through March. They were going to contact Keystone. Our Keystone housing advocate, Bettina Gregory, is here with us, been here all afternoon. Miss Gregory, are you plugged into this one?
Yes, sir. My last name's Emery.
Yeah, I'm sorry. I keep calling you Gregory. I know it's Emery. And I apologize. It says right on my screen, Bettina Emery, and I wrote it over here on a little sheet so I won't forget it. So keep correcting me when I keep doing it wrong. Bettina Emery.
Yeah.
I don't know who Bettina Gregory is, but what's the status here?
We have not been in contact with Ms. Van Dyke.
Ms. Van Dyke, did you ever contact Keystone?
No, I did not, Your Honor. I was counting on the stimulus checks, which his is coming on Wednesday. That's what they say on the recording, and mine is supposed to be here sometime this week. All I have right now is enough to stop the bleeding, which is April rent.
All right, well, I suggested that you contact Keystone, and you said, well, I want to wait till I really need it.
Right,
And,
I really need it now.
Well, you really needed it then. Now,
I know.
If we add in April's rent, Ms. Hull, what's the current arrearage? We had 560 to the 1730.
I have $1,400 without court costs because when I'm looking at the ledger, I take out the court costs. I see $560 for April and March and February.
Well, they did owe $1170 plus some late fees, and then that was through March. All right, well, anyway, I'll just let you give me your figure.
Well, I have $1,400 before costs, and then the costs are $248.42 for a total.
So did they pay something since our last hearing?
No, there was a payment of $300 on March 10th.
I do have it right now. I have the whole March rent right now.
All right.
Okay, so
I mean,
essentially,
not March, or whatever, a month rent.
When there was the last payment before that on February 3rd, her balance was $560. Then there was a late fee of $10, and then March was added, and then court costs, and then there was a payment of $300, and then April was added. So I come up with $1,400, which includes April rent.
All right. Miss Van Dyke, I would still say that you should contact Keystone. They may be able to give you some emergency help.
Okay, I sure will.
I find that through April, the rent is $1,400 plus $248.42 in cost. That's $1,648.42. That's due by April 15th, or you're subject to being evicted. They don't have to evict you on April 15th. They have 56 days from today to ask for the writ of eviction. Now, you've got some stimulus money coming, which may be great and get your rent paid through April, but then you're going to be up against it in May again. If Keystone is able to help you, I encourage you to try to do that. Now, something that you have not done, the federal government stayed all evictions until April 1st because of COVID. That expired and they renewed it through June 30th. You have not asked for a stay of eviction. You could also do that. You can get the form on the internet. But if you pay your rent, $1,400, $248 in costs, you're good through April. Now, let me give you the Keystone number once again. Bettina, would you say it?
Yes, Your Honor. 269-467-7078, extension 117.
Okay, do you have any questions?
No, I do not.
All right, I'll send you a copy of that judgment. Ms. Hull, I don't think I have one. Could you email us a judgment?
Yes, I will.
All right, thank you.
Okay, so we're all set, Cynthia?
Yes. Stay in contact with your manager.
Yes.
And call Keystone.
Okay.
Okay.
I sure will. And I thank you very, very much.
All right, thank you. I hope this works out. All right,
It
Ms.
will.
Linda, I'm going to remove you.
Thank you very much.
So, thank you. All right, Ms. Green. Any moment now, I'm likely to be kicked off the Polycom because I've been on the record for 9 hours. I've been sitting here almost, with the exception of about 25 minutes at lunch. If that happens, you won't be able to hear me and I have to re-sign on. All right, this is Ms. Hines' turn. This is entitled Marcus Walton versus Anthony Robinson. This is a termination of tenancy. There was a month-to-month lease. The lease had expired and the plaintiff wanted the defendant to move. We had our initial hearing last week, March 29th. The law requires that I set 2 hearings, and the second hearing is set for today. Mr. Robinson, what's the status here?
Well, I got my job back in R&R Trailers, and I've been trying to contact Marcus, and he won't answer my calls. I did the SER, the State Emergency Relief or whatever, and they told me that I had to do the CERA, which is the COVID Emergency Relief Association. So I got applications, I filled mine out. I sent one to Lori Hines to give to Marcus, and I don't know if he filled his out, because he told me he was going to work with me and try to get, as long as I got funding, that he would help me out, you know. So I tried my best, and I've actually worked on the apartment, got all the linoleum down because there was bed bugs when I moved in there, and I'm trying to do my best, you know. So I don't know what his status is.
All right. Well, what's the defendant's position, Ms. Hines, or the plaintiff's position?
I didn't get any documents from Mr. Robinson, and my client wants him out of the apartment.
Mr. Robinson, your case is a special type of case. There's one way they can file this is a termination of, a non-payment of rent, saying he owes January, February, March's rent. It's $500 a month. So he has to pay $1,500 or move. Okay, that's one way to do it. They didn't do that. They filed a termination of tenancy, which comes in a couple different varieties. One is the people are violating the lease. They're materially in violation of the lease, and we want them to move. They're not alleging that. They're simply alleging that you have a month-to-month lease, and they want to exercise their right to terminate the lease. They're not alleging that you did anything wrong. They're not asking for money. They simply wish to terminate the lease. You have a month-to-month lease. They served a notice to quit on you on January 24th. Now, I don't know whether Mr. Walton was giving you mixed signals or not. Mr. Walton, did you tell him if he paid the rent, you let him stay there?
Yeah, I did. I told him I'd work with him, but every time we would talk on the phone, his actions would show otherwise. He lost his job. And
just a minute, I can't hear you very well. Go ahead.
He had lost his job, and I sent him all the contact information to Keystone. Zita was the case manager he needed to speak to. I sent him everything he needed in January, and he took no action. And then it was very difficult to even get in contact with him. He wouldn't return any of my calls, any of my text messages. Then he threatened to sue me for harassment.
I don't know, you're in Texas, maybe we can't hear people from Texas, but you sound like Charlie Brown's teacher. You got a very poor microphone connection, and I'm sure no one else could understand what you said either. But it sounds like you said you'd work with him, and so you got to figure out which foot you're on. If you want to terminate his tenancy, terminate his tenancy. But then you say, oh, by the way, I'll work with you if you pay the rent. So he contacts Keystone, and Keystone's got money to pay his rent. And thousands of dollars worth of back and prospective rent. So he contacts Keystone, starts the process to get the rent paid. Except you told him, now you don't care about the rent, you just want him to move. So he wouldn't have gone to all that rigmarole to apply at Keystone if you were going to ask him to move anyway. Just out of curiosity, how far is the rent in arrearage?
He hasn't paid since January.
So he owes February, March, and April?
January.
So he owes January. So did he pay January's rent?
No.
No. So he owes January, February, March, and April.
I gave him 300 last week, so.
All right. Oh, I didn't know that either. So
Yeah, I
you
told you
filed a
last week.
termination. All right, you filed a termination of tenancy and you're accepting rent in the meantime.
I don't think my client accepted any rent. When I talked to him at the last hearing, he said he hadn't gotten any payment. Marcus, can you verify for the judge if you received any money from Anthony Robinson?
Yeah,
I can email you the receipt.
he went to the bank and deposited $300. I hadn't spoke to Anthony in almost a month.
Because I lost my phone. Somebody stole it.
Mr.
at
Robinson,
Walmart.
stop. Only one person can talk at a time. Don't just blurt things out. I'll give you a chance to speak. It's bad enough that you're here only by telephone, so we can't see you, but just wait, and I'll give you a chance to speak.
I apologize, Your Honor.
Continue, Marcus, please.
Your Honor, in January, when I was made aware that he had lost his job, I told him that I would work with him if he could find a job. He found a job, but then proceeded to lose the job 2 weeks later. At that point is when I reached out to my attorney and started the process to get him removed from the property.
All right.
Initially,
And then since then, he made a $300 payment into your bank account?
Yes, March 26th.
So that was after our last hearing, or right before our last hearing.
Correct.
And you didn't know about that payment until after the hearing, is that right?
Correct. The day of the hearing is when I found out.
And then did you check the bank?
Correct.
Okay.
All right. How much is the rent per month?
$700 plus utilities.
Has he paid his utilities, Marcus?
No, he hasn't.
Bettina, did Mr. Robinson contact you?
Yes, Your Honor, he did.
What day was that?
My intake representative has made contact with Anthony today. I believe Anthony contacted us around March 23rd.
All right. All right. That was before the hearing.
Thank you.
Yeah, he testified last time, the defendant did, that he paid some rent. And then the defendant says he's paid no rent, but apparently he had paid some rent and it hadn't, the landlord didn't realize it yet. So that was the first hearing. We continued it till now. Mr. Robinson, he's asking to terminate your tenancy and have you move out. Keystone would be available to pay your rent, probably $700 for January, $700 for March, $700 for February, $700 for April, probably $700 for May, which is $2,800 plus the utilities, about $3,000. So he says he doesn't want that. He simply wants you to move.
Okay.
Although he did accept money, but he didn't know it because you made a direct deposit. The law says you have 10 days from today to move or you're subject to being evicted.
Okay.
I'm not ordering that you pay anything. There was an avenue to get about 5 months of your rent paid, probably $3,500, which could go to him, but he doesn't want to do that. So it means you got 10 days to move or you're subject to being evicted. Now, when you move, you need to turn in your keys and give your forwarding address in writing. He may then sue you for this back rent and that's an issue for another date. Ms. Hines, I'll ask you to just submit a possession judgment.
I did, Your Honor. I emailed it to you while we were.
All right, maybe they'll bring it. Mr. Robinson, do you think you can move in 10 days?
Yeah, I'll figure something out.
All right. Now, let me say this. Don't pay any more money. Just prepare to move. Turn in your keys and give your forwarding address in writing within 4 days of your moving. If he wants to sue you for money damages, he can do that. Keystone was available to pay your rent, but he doesn't elect to do that.
Okay.
All right. Save your money and on your next place, I guess.
Okay.
Do you have any other questions?
Yeah, I just want to say God bless you, Marcus. I'm glad you're a great frickin' person.
All right. Well, that's enough of that. I guess he can do what he wants. I would have opted for the money, but he elected just to proceed. He hung up. All right, Mr. Walton, you're good to go. Ms. Hines has submitted a judgment. Bettina, I guess you don't need to worry about processing that case. Not like you don't have a bunch of others. Thank you, Lori.
Thank you.
All right, we've got iPhone and Matt Davidson. This is Terea Patrick.
Sure.
Hello.
How you doing?
Good. Set Miss Patrick. Oh, there it is.
Happy Monday, Bettina.
Happy Monday. How are you?
Monday.
Okay. All right. That one we did also. All right. We're on the home stretch of a very long afternoon. We've moved in this chair since 1 o'clock. This is entitled Maple Crest Apartments versus Terea Patrick. File number is 21382LT. This was filed as a termination of tenancy. The plaintiff alleged that Ms. Patrick did violate the lease and endanger the material enjoyment of other tenants in the premises. Multiple police calls to the unit, disturbance, allowing others not on lease to stay in the unit, depriving other residents of the right to peaceful enjoyment of the leased premises, disputing the livability of the building. That was served on November 17th by the manager, Lori Bowers, who's present. Then that started this process. And the complaint to recover the property was filed by Mr. Davidson on March 11th. And we had our first hearing on March 29th, and the matter was continued until today. I spoke with Ms. Patrick earlier today. Ms. Patrick, you've had a transformation. You didn't look bad this morning, but you look very nice this afternoon. You made an effort to be ready for this hearing. What's your position, Ms. Patrick?
As far as what do you mean? Like, how do I feel about the situation? Or
Yeah, are you willing to move, or do you wish to have a hearing regarding this?
I would like to move, but because I don't believe, I just feel like it's a battle of the neighbors. It's the same person doing, like, calling the police over and over. I do have a 2-year-old son. I have had company over, and I have had police come and let me know, like, it's not too loud, or it is a little bit loud or whatever. But I've also talked to her, because I'm an easy person to get along with, and it's, it's not fair to her that if I'm loud or something or disturbing, But at the same time, as a neighbor, it's not like the walls are hollow, like, you know. So I talked to her, I pulled her over to the side a couple of times to talk, and there's an adult, you know. And, you know, she seemed like everything was fine, but still, like, I could probably drop a needle on the floor and she'll be banging on the ceiling, and it'll just be me and my son, and, you know, no, you know, just us. So I'm like, darn, like, you know, that's kind of unfortunate. And then the police constantly coming to the house. I talked to the other neighbors. I don't know if they were, you know, telling the truth or not, but it's the lady that lives under me that keeps filing the complaint.
Now, I don't know about that, but that was back in November that they filed the notice to quit. And you're entitled to have a hearing regarding this.
Okay.
I gave you the information about contacting legal aid. Did you contact them?
They said they were giving me a call back. I've been waiting for a call back.
Ms. Bowers, can you connect?
Can you hear me?
Yes. Do they have the ability to do video?
No, I tried. I'm not able to. If I ever have to come back to court, I'll pre-do it to make sure I can get it.
All right, thank you. I suppose it doesn't matter, but she contends that it's just one person making all these complaints. What's the plaintiff's position on that?
Lori, will you answer the judge, please?
It's multiple people, not just one, but we just want her to move.
I haven't had any of these with Matt. I've had a number of knockdown, drag-out, termination tenancy hearings this year. I had one that took 2 full days, and I've had maybe a dozen that I block out time and we take sworn testimony about why they wish to terminate the tenancy. Ms. Patrick, if you get evicted from here, it may make it very difficult for you to get other housing. I just had a very lengthy hearing from a woman in a tenancy in Sturgis, and ultimately I ordered that she move, and I wish it hadn't been so, because now she's got an eviction on her record. She was represented by legal aid and well represented, but there was enough evidence to terminate the tenancy. So she got evicted, or she's being evicted, and now she probably won't be able to get into her next place.
Right.
They are saying we have additional witnesses. Are there also police reports and that sort of thing?
Yes.
Now, Ms. Bowers, just a minute. Was there a contention that other people were actually living there?
There was at a time. She went away. My understanding, after she came back in June 16th, her dad got sick. She said that she went to take care of her mom who had COVID. Somebody moved into her unit, and the police were called constantly. In October, she returned after multiple phone calls from me. I even called her sister trying to contact her. And she said she came home because she's behind on rent, and she found that rent hadn't paid. And she said she didn't know they were staying there. But she gave them keys because how else can they get in? And they caused all sorts of havoc at that point. And then later we had another couple staying in there. They were so quiet, the neighbors thought I had rented it to somebody new. And that's against her lease.
All right, well, just a minute. One of the problems is she doesn't have a very good notice of what it is she did to violate the lease. This was an issue in the case we just had. They were well represented by legal aid, and with the termination of tenancy is based on what's in the notice to quit, and this notice to quit ain't exactly the greatest.
Your Honor, it was my position, and it remains my position, that in a 30-day eviction, that those aren't factual issues. And the reason that I bring that up is, let's say, for instance, a landlord were to say, my son and daughter-in-law are going to have a baby, and I want them to come home and move into this house, so I'm evicting you. And later the son and daughter-in-law were to say, well, we don't think we're going to come back to Three Rivers. It wouldn't prevent the eviction from happening based on the truth of the allegation. I mean, it wouldn't be based, because you could leave it blank and it would still be valid.
The rules are different for federally subsidized housing. There are some very specific rules in the federal code that were cited by legal aid last week to Mr. Thornton. Yeah, in a federally subsidized housing, you're limited to the allegations in the notice to quit, and it has to be pled with some specificity. The rules are different and stricter for federally subsidized housing. This just says multiple calls to the police unit, disturbances, allowing another's not on the lease, that's clear, depriving other residents of the peaceful right to enjoyment, disrupting the livability of the premises. She has a right to have a hearing where those things have to be sworn to and testified to under oath. This started way back last October, and then they gave you quite a bit of time to leave, and you didn't leave, and then they didn't file the actual action until sometime later. Anyway, the bottom line is you're entitled to have a trial on these allegations, where the neighbors come testify, the police reports come in, the police come in, and they tell their side of the story, and you tell your side of the story. And as I said, I've had a number of these this year, and they're very demanding and time-consuming. But the tenants are entitled to have a hearing where it must be proven that they violated the lease. So we're going to have to set such a hearing. The problem is finding a place to put it. Once upon a time, we used to actually try jury trials on Wednesdays. We don't do that anymore because of the COVID stay.
Your Honor?
Yes?
She's also $412 behind on rent, which is 4 months.
I thought it was just this month and March, April and March, because I got the eviction notice, so I was trying to see what was going to happen because I don't have any money or anything. I'm waiting on my unemployment, so I need to know what I can.
Somehow I lost control of this. People are just blurting things out. If we were sitting in the courtroom, probably wouldn't do that. You have a lawyer that represents you, so you took over and then she responded. But it isn't a non-payment of rent. Ms. Patrick, I would advise you not to pay your rent. They're trying to terminate your tenancy, and they want you to move. So irrespective of whether you pay your rent at this point, they're going to ask to terminate your tenancy. We have to figure out what we're going to do. And again, if you get evicted, it will probably make it either difficult or impossible to you get into other federally subsidized housing. It's a big black mark on your record. So you are behind in the rent, but once they file the notice to quit, I probably wouldn't have paid the rent either. But I would have moved. Matt, I have a window here. I just set something for 1:30. Are you available on Wednesday, April 28th at 1 o'clock?
I will
Yes.
be.
I'm sorry.
All right, we're going to set this for Wednesday, April 28th. At 1 o'clock. Now, I just tried that other case, Ms. Patrick or Mr. Davidson. I think it's still up on YouTube. So if you wish to watch how a termination of tenancy trial goes, you can look it up. It was vigorously defended by legal aid, as I stated, and there were a number of defenses under the federal code. Ultimately, I ruled that she had to move and gave her 10 days to move out. Now, Ms. Patrick, if you agree to move voluntarily and you decide to leave, you can turn in your keys and give your forwarding address in writing within 4 days of your moving. And that would have the case dismissed, and it would not put a eviction on your record. So I've continued this for a trial for April 28th. You can still have a trial and have them produce evidence of how you violated your lease. You can also hire an attorney to represent you, or you can again ask legal aid if they would represent you in this matter. But even though these things are old, they're the reason why they want to terminate your tenancy, because they're not sure you won't do it again. And I don't know who was in there. If you're in your unit, it looks clean and nice. You were in it this morning, but they allege there was damage to it. At those points, they're only allegations. But I've blocked out the whole afternoon, which I don't have a lot of afternoons.
No, there's no damage that I could have called done.
What's that?
I said there's no damages in there that that I could have done. I mean, there's like one of my drawers in my kitchen is like hanging down, but there's no major damages. I've been there since August 2018, so I'm not sure.
I don't know any of that, but that's what she just said here on the record. So I don't know who was there or how long they were there or what they did or what's in the lease. You're entitled to present any witnesses you wish to present at that time also. So let me repeat, we're setting this for a trial where they're going to have witnesses testify under oath as to what you allegedly did to violate your lease. You're entitled to testify under oath yourself and tell your side of the story. You're entitled to present witnesses. Hopefully we can do this in 4 hours. I've got another case in there somewhere that will take a little bit of time, but I just said it there and I can't remember what it was. So, but if you decide to just move and not run the risk of being evicted, you got 2 weeks to do that. And, but you're not going to find somewhere where your rent's $104 a month. So it's very difficult. And people say that I would move if I had somewhere to move to. But I don't. And your rent is $104 a month, and nowhere are you going to be able to find a nice apartment like that for $104 a month. So it's a difficult situation. You're between the proverbial rock and a hard place. And now you owe me a bunch of money on other matters. And that's not great. But you got some heavy thinking to do, and if legal aid will assist you or other attorney, that's fine. Otherwise, we're going to have a hearing on that date, April 28th at 1 o'clock. We'll block out the rest of the afternoon and see where we go from that point. Mr. Davidson, anything to add?
Will this be a Zoom hearing, Your Honor?
Yes, it will. Thank you.
What are the requirements for producing evidentiary documents or providing them to Mrs. Patrick?
Well, you
Typically,
submit
we
them.
do that by email.
You can watch some of these. We did some zoning hearings with Roxanne Seaver. She did a nice job of screen sharing the pictures. We did a animal control case with Casey Johnson. He did a very nice job of screen sharing the pictures and the videos. And then, of course, the witnesses will be connected by Zoom.
I've done such hearings. I just would typically have counsel on the other side to whom I could email exhibits, and then I mail them to the court, and then the court looks at exhibits. I'm not sure how many we'd have in this case, but we would have a lease. We would have certain exhibits, and I'm just not quite sure how the court would
Well,
want me
she
to proceed with
should
an
have a
improper.
copy of the lease, but go ahead and submit any photographs you wish to submit and mail them to the defendant. I think what we
Yeah.
did is we numbered each of the photos and then we referred to the photos by number. We've done it varying different ways, but obviously, as you know, Zoom has complicated our lives. All right, Miss Patrick, you've got a lot on the line here. Is there anything else you wish to ask?
Yes, I was wondering, would I be able to go down to the police station myself and get a copy of those police reports against me? Or
Yes, you should be able to. They have a form, a Freedom of Information form. Yes, you should be able to get those.
okay, okay.
All right. Anything further?
Thank you, Your Honor.
No, that'll be all. I'll just
All right.
have.
That'll be a very busy day. I'll be just returning to court the day before, but we'll be prepared. I don't have big blocks of time like this. I have to fit them in where I can. And that particular afternoon happens to be open. So we will do the best we can on that date. All right. Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Davidson. Ms. Bowers. Bettina, we had only, I think, one home run today. We had a couple near misses, and you got a couple in the pipeline. Thank you for toughing out the whole afternoon here. That guy, one guy, he had an opportunity perhaps to get in on the program and chose not to, so we can't make him do it. All right, well, very busy. We'll be back Friday, and then that's the 9th, and then we'll be back on the 12th, and then we won't back again till the 30th of April. Although Judge Pattison will be covering the 23rd, I think is the day he's going to be here.
Okay.
All right, thank you.
Thank you, Your Honor.
All right, that completed a very busy afternoon. There were about 40 cases. We did the best we could. We will resume tomorrow in the morning. It's criminal pre-exam conference day. And we'll be very busy tomorrow as well. All right, we'll end the live stream and stop the recording.